Hi, everybody, and welcome back to Workplace Compass. This is the final episode in our mini series looking at the trade union and industrial relations changes under the Employment Rights Act 2025. My name's Jess, and I'm joined again today by my colleagues Bob and Ellie.
Hi everyone, I'm Bob, a partner in the employment team.
I'm Ellie, a partner in the team and independent schools specialist.
So in our previous episodes, we looked at the new right of access for trade unions, the duty to inform workers of the right to join a trade union, and changes to recognition and balloting. So today we are turning to industrial action and in particular the new protections for workers who take part in it. So Bob, would you mind kicking us off then with a little bit of background to these changes?
Sure. So the key driver to the changes around more significant employee protections was a decision in a case called Secretary of State for Business and Trade and Mercer, where the Supreme Court found that UK law didn't go far enough in protecting workers who take part in lawful industrial action. In particular, while there was protection at that point against dismissal in certain circumstances, there was no clearer protection against other forms of detriment. So things like being denied promotion opportunities or being treated less favorably in other ways could have fallen outside of the existing framework.
Right, so that's what the Act is seeking to address then, is it?
Exactly. Yeah. So the Act strengthens the existing protections around dismissal. Those changes have actually already taken effect from February of 2026. And then it also induces a new right not to be subjected to detriment for taking part in lawful industrial action. And that's expected to come into force in October of 2026, subject to the outcome of the consultation.
Right, okay. So all changes that are happening over the course of this calendar year then. Right. So Ellie, then if we bring you in here, would you mind talking us through what the new protection against detriment looks like?
Yes, so the new right means that employers must not subject workers to a detriment because they have taken part in lawful industrial action. And that's likely to be interpreted quite broadly. So the current consultation suggests that the government's preferred approach is to prohibit all forms of detriment rather than defining a limited list.
So what might that include in practice then?
Well, potentially a wide range of things. For example, decisions around pay, promotion, training opportunities, allocation of work. The challenge for employers is that it won't always be obvious where the line is. So, for instance, if someone misses out on a bonus or an opportunity because they were absent during industrial action, is that a natural consequence of absence, or really could it be seen as a detriment? So that's where some of the uncertainty sits at the moment.
I can see that. So we're waiting for the consultation outcome then in respect of that. And then turning then to protection against dismissal. How is that changing?
This is a fairly significant shift. So previously, employees taking part in lawful industrial action were protected from dismissal only for a limited period. And typically that was the first 12 weeks of industrial action. After that protected period, employers could potentially dismiss, provided certain conditions were met and the automatic unfair dismissal wouldn't apply. The Act removes that distinction. So now employees will be protected from dismissal for the entire duration of lawful industrial action, regardless of how long it lasts. And that's a change that has already come into effect. It took effect in February 2026.
Right. So what that means then is that for employers, the option of effectively waiting out a dispute is sort of no longer there.
Yes, that's right. Waiting out a dispute before they take some kind of disciplinary action, the risk now remains. That changes the dynamic quite considerably, particularly in sectors where industrial action can be prolonged.
So what does all of this mean in practice then for employers?
I think the key point is that the balance shifts more towards managing the relationship and resolving disputes. Employers are likely to need to take a more proactive approach to industrial relations, something we've said before in this series, particularly in terms of early engagement and communication.
And it's worth as well remembering that we've already seen some related changes come in to effect earlier this year, which kind of add to this changed landscape. So, for example, the extension of the industrial action ballot mandate has been increased from 6 to 12 months. And again, that means that unions can sustain action for longer. without needing to reballot. And so I just wondered, Ellie, from a school's perspective, what really stands out to you?
Yeah, I think it's the potential for longer running disputes and the knock on operational impact. So, in schools, disruption doesn't just affect the workforce, it affects pupils, parents, and the wider community. So, the focus is likely to be on preventing those disputes from escalating in the first place and then managing them carefully if they do arise.
I think that's really sensible and pragmatic advice, Ellie. Thank you. And I suppose then what that leads us to think about is similarly to in our previous episodes, it really all comes back to what employers should be doing now. And Bob, where would you start on that?
I would recommend starting with a review of existing policies and practices with a view to the management of risk, essentially. For example, look at how decisions are made around pay, bonuses, performance management, promotion, and ask whether those processes could inadvertently create risk in the context of industrial action.
Yeah, absolutely. And what about records and documentation?
Yes, that's important as well. Clear, consistent records of decision making will be key if an employer needs to show that a particular action wasn't linked to industrial action, but was for other good reason. So, yes, I definitely agree there.
Yeah, thanks, Bob. And Ellie, anything to add from your perspective?
Yeah, I think training is going to be really important. Managers will need to understand how these protections work in practice, particularly where there are those grey areas. And employers should also think about how their existing arrangements, things like bonus schemes or attendance related incentives, operate in the context of industrial action.
Thanks, Ellie. Yeah, I think all of that is really useful, practical advice for what employers should be starting to think about now. So, if we just pull all that together to conclude, the new protections around industrial action are significantly going to strengthen the position of workers, both in terms of detriment and also in respect of dismissal. So, for employers, as you said earlier, Bob, that really does mean that there's going to need to be a really strong focus on the sort of proactive and positive management of the relationship, as well as needing to make well reasoned decisions and making sure that policies, procedures, and records stand up to scrutiny. Bob, I wondered whether you've got any final thoughts to share.
I think it's about being prepared and thinking strategically. So, these changes don't just affect how disputes are handled, they affect how organizations need to think about industrial relations in a more general sense.
I think that's a really good point. And Ellie, I don't know if you've got any final thoughts to share with us as well.
Yeah, well, I mean, I'd agree. It goes without saying, employers who are in the strongest position will be those who have taken the time to review their approach now, rather than reacting once those issues arise.
Thanks both. That was really useful. Thank you for sharing your thoughts and your insights into this area of change under the Act. And thank you to everybody who's listened to this mini series. We hope you've found it helpful. Please do like and subscribe to this Workplace Compass podcast series to make sure you don't miss any future episodes, because we will be back soon with a new mini series. So until next time, bye bye for now and take care.
Bye.